Constitutional issues are very prevalent in land use and arise from federal sources, state statutes, and case law. You should pay attention to them because they're important and they will affect the outcome of land use development applications from each side of the table. The principal constitutional requirement is procedural due process, which arises under the U.S. Constitution, Fifth Amendment, and the 14th Amendment, which makes that applicable to the states. Procedural due process is important because people are entitled to have their issues fairly heard and decided by decision makers. One of the key elements of due process is the notice of what's happening and the opportunity to be heard, which enables participants to engage in the process in a meaningful fashion with an understanding of what's at stake and what the issues are. Procedural due process has historically been the realm of the courts. In the 1940s, the administrative branch of government started to develop, and cities and counties and towns were authorized to begin making judicial type decisions about people's rights and their property rights in particular with regard to land use. And so what's happened is that there is a procedural due process right in the courts, but there's also a procedural due process right at the administrative level. And that right arises when decisions are made by those entities that are called quasi-judicial decisions. Quasi-judicial decisions are discretionary decisions that affect the rights and obligations of specific parties that are in front of the hearing examiner or planning commission, as the case might be. Besides quasi-judicial decisions, there are ministerial decisions, which are decisions made by administrative entities based on, for example, land use regulations that are not discretionary. For example, if your building is 37 feet and the regulation only allows 35 feet, they can't permit that, and that is a ministerial decision. Besides procedural due process, there is a substantive due process requirement in the Constitution that focuses on the outcome of actions and whether they are unduly burdensome on the individual involved, despite following all the rules and the regulations. There are four basic questions that are asked in evaluating a substantive due process question. The first of those is whether or not the regulation has a legitimate purpose. The second is how appropriately those regulations accomplish the purpose. The third is that the regulations are themselves reasonable. And the fourth is that the regulations are clear and able to be understood. If those questions are met and answered appropriately, then there is no substantive due process violation. The Washington Constitution provides takings protections as well, and it's coextensive with the federal protection, except that it adds two elements. The first is that just compensation must be paid first before the property is taken, and the second is that just compensation must be paid even though the property is only damaged and not physically acquired. Thus, you can see that there are two basic types of takings. One is a physical appropriation of property, for example, when the city takes road frontage so that it can expand a street. And the second type is called a regulatory taking, which occurs when the use of property is substantially impaired by the regulations that define whatever is permissible on that portion of the property. There are two related concepts to this. One of them is called exactions and dedications. And exactions and dedications essentially are conditions that are placed on the development of property by the deciding entity. And they can be requirements to pay money, they can be requirements to contribute property, for example, open space for neighborhood parks, or they can be conditions on the size and development of the property itself. However, most exactions and dedications have to meet two tests. The first of those is that it have a nexus with the issue that's involved. So, for example, if a project will block the view of the shoreline, for example, then the condition that would mitigate that impact has to address the view, not, for example, require a street to be expanded in front of the project. The second element that's applicable to exactions and dedications is proportionality, which simply means that the remedy for the impact cause has to be proportional. If you're going to develop a 12-unit subdivision, you can't require the developer to build a 5-lane freeway in front of their property as mitigation for the traffic impacts. In the takings world, there's a related concept which is called reasonable use. And reasonable use provides that if the regulations that apply to your property are so severe that you can do nothing with it, then the jurisdiction will allow individuals to have a reasonable use of that property and thus avoid a claim for constitutionally taking their property without just compensation. Washington has a unique vesting statute which provides that applications vest to the land use regulations in effect at the time the application is filed. Washington also allows cities and counties to impose moratoria on development actions. There is common law authority as well as statutory authority. The purpose of these moratoria is to enable a jurisdiction to call a halt to applications for a specific time period, usually 6 months, while they determine whether or not the regulations that they have are sufficient to address the issue. If they are, the moratorium is over with and applications can be resubmitted. If it's not, the jurisdiction can adopt new regulations, and then again, applications conforming with those regulations can be submitted. One final statutory protection that Washington provides in the land use context is RCW 6440. And RCW 6440 allows individuals that have received a negative or adverse decision to appeal to court, and if they're successful, to obtain their attorney's fees. It was adopted to offer an incentive to local jurisdictions to avoid arbitrary and capricious decisions and pay attention to the regulations that actually apply to land use decisions and applications. The First Amendment to the U.S. Constitution, of course, provides that people are free to express themselves, and that has two applications in the land use context. The first is usually in the religious context with regard to the establishment of churches and the operation of the churches, particularly parking and those kinds of regulations. The second typically applies more to the realm of adult businesses and the free expression that's allowed to individuals in those situations. The Equal Protection Clause is designed to protect classes of individuals from discrimination, and there are three basic elements to this. One is that the individuals be treated similarly in similar situations. The second is that the jurisdiction have a rational basis for the regulations that they've adopted. And the third is that if fundamental rights like voting are affected, that the courts will employ strict scrutiny to ensure that there is no equal protection violation. As you can see, the land use world is complex in many different varieties, and it's difficult to understand, and the rules are often gray and ambiguous. So be sure to read the manual, learn more, talk to your city attorney, and understand how the rules apply so that you can avoid problems in your jurisdiction when facing these issues.